So we are going to turn to your next form, which is not really in order. It's form FL-115, FL-115. It's called a proof of service of summons. Good. Okay. This form is the only form that the court goes by to see if the other person has been served. It doesn't matter if you've actually served them. If you don't file this proof of service, it's like you didn't do it. This is probably one of the most commonly missed forms out there. Service must be done in person by somebody over the age of 18 who is not you. It can be your best friend, it could be an adult child, it could be a coworker, it could be somebody you paid $20 off the street to do it. It just has to be an adult who isn't you, who physically, personally hands them the papers. They don't have to say anything, they just have to hand them the papers. You will need to fill out the caption like you always have before, your name, your mailing address, your phone number. You'll need to put the court's address. Now that you have a case number, you are responsible for filling out your case number each and every time. The clerks will not do it for you. Because all of you are here for a divorce and not a dissolution of domestic partnership, you are going to be checking A, 1A. They were served with the petition, the summons, and what we call the blank response, the 120. Anytime you serve somebody documents, you have to give them the documents with which to respond. So you're going to give them filed documents of the petition and summons, as well as a blank response. Why? Because they're obligated to file the response if they want to participate in the case. If you have minor children, you are also going to check E1, which is the UCCJEA. That's regarding the jurisdiction of your minor children. And you're going to give them a blank of that as well. Number 2, you need to fill out where the respondent was served, whether it's their home address, whether it's at work, whether it was at the local Starbucks. You need to fill out the address completely. Again, this form is incredibly important. If you don't do it right, you're not going to get divorced. Number 3, personal service. You're going to check the box, personal service, on whatever date at whatever time. California does authorize substituted service. I don't recommend it. It makes your divorce that much more complicated, and the rules are far, far, far more complex than personal service. It is much easier to have somebody physically hand them the papers. Any questions on page 1? All right, we're going to skip to 3C, which is mail and acknowledgement service. We're going to toggle a little bit back and forth. If you go to your form FL-117, which is the next form, that's called a notice and acknowledgement of receipt. So I'm going to put 115 aside and go very quickly to 117. This is an alternative of personally serving the party, meaning you can do it by mail. It still has to be somebody over the age of 18 who isn't you who mails it. But it can be done by mail if the other side is willing to sign an acknowledgement saying that they've been served. If you don't trust the other side, if they are not the most responsible person in the world, you're probably never going to get this back. So my recommendation typically is personal service. That guarantees that the document is done and it puts the control in your hands. You're not waiting on the other side to respond. You're not waiting on the other side to give you a document back. You're not waiting. Instead, you get to fill out the form and you're in control of your case. If, however, the two of you are cooperating, sometimes even if you're living in the same house, you can mail it out, mail it right to yourself, and they are acknowledging that they received the following. A, which is the petition, the summons, and the blank response. If they have minor children, again, it's E1, the completed in blank UCCJEA. The person who is being served must date, print, and sign their name. The person who is serving must say the date of mailing up here, their name, and their signature. Is anybody considering serving by mail? Okay, then I will not spend any more time on this form. So we're going to go back to page 2 of the proof of service of summons. You'll want to fill out number 4, If you remember back on your summons, you are serving them as an individual. You're suing them as an individual person. You'll need to check this box, 4A. Number 5 is the person who served the papers. So whoever is the person giving the papers to the respondent, your spouse, needs to fill out their name and a mailing address. Again, if privacy reasons they don't want to do their home address, there has to be an address where the court and you can reach them. Phone number. The reason why this is important is if the other side claims that they never got the papers, the person who did your proof of service, they're going to have to testify that they were served. Okay. If you've hired a registered California process server, they'll need to fill out all of the official information. There are a lot of process servers in the county. You could probably do a Google search, and that's somebody who's actually licensed to serve papers. You don't have to have a registered process server. If they are not a registered process server, then you leave it blank. You just put B, not a registered process server. That person must declare under penalty of perjury that he or she served the other side, date, print, and sign. Again, because this is somebody else filling out and signing the form, it's very important that you make sure to do it correctly. A lot of judgments are rejected because this document is not filled out properly. Without proper service, you can't get divorced. Without filling out the proof of service properly, you can't get divorced. Any questions on the proof of service?